say you will.
Hi guys, welcome to the channel. Please go ahead, hit that like button and subscribe if you haven't already. So on yesterday, I brought you guys an update in the case of Destiny Payton from Love and Marriage Huntsville. She filed an emergency motion against her ex-husband, LeBerick Williams. Well, today it looks like LeBerick has responded and filed his own motion. I have the update ready for you guys. The documents will be on the screen. As we can see, this document was electronically filed August 26th. 2025 in the Circuit Court of Madison County, Alabama, and it is titled Response to Verified Emergency Motion to Prohibit Corporal Punishment of the Minor Child, to order both parents to participate in the evaluation of the minor child and for such other protections deemed necessary. And it reads, comes now. The plaintiff buying through the undersigned counsel to respond to the defendant's verified emergency motion to prohibit corporal punishment of the minor child, to order both parents to participate in the evaluation of the minor child and for such other protections deemed necessary, asking this court deny the same, stating as follows. Number 1. The plaintiff denies each and every material allegation made in the defendant's motion and demands strict proof thereof. Number 2. This action is before the court on the defendant's petition for rule nisi and modification filed on May 10th, 2024, where the defendant claims without supporting evidence that the plaintiff practices corporal punishment of the minor child. Number 3. Now, more than 1 year later, the defendant brings to this court an emergency motion requesting this court enter an order prohibiting corporal punishment of the minor child, pleading as follows. The defendant avers to the best of her knowledge and belief that she is concerned that the plaintiff has been inappropriately employing corporal punishment to discipline the minor child. Number 4. The defendant's motion is laden with hearsay and supported by only the defendant's own unsubstantiated assumptions about what she believes to transpire in the privacy of the plaintiff's home during his custodial time with the minor child. Number 5. Despite the absolute lack of any supporting evidence apart from her own verification, the defendant requests this court take immediate emergency action to change not only education decision-making authority, but also primary physical custody of the minor child. Number 6. Such a dramatic change in custody is not in the child's best interest and further is not warranted under the facts and circumstances at hand. Number 7. As this court's March 3rd, 2025 order specifically noted, the defendant's allegations have been pled and tried repeatedly in the parties' domestic relations pleading. The defendant's August 18th, 2025 motion is simply the most recent in a long line of attempts to bring about the same end under the same set of allegations, reiterated in different formats at different points in time. The defendant's current renewal of claims related to the trauma that the minor child has faced happens to coincide with the defendant's launch of a nonprofit for survivors of domestic violence named Destiny's Law Foundation, which the defendant purports to be named for herself and her son. Number 8. In addition to reviving the aged claim of concerns of use of corporal punishment, the defendant has likewise previously brought to this honorable court by way of a petition for protection from abuse and an action DR 2020-003 296.03, the claim supported only by the hearsay statement of the then 3-year-old child that the child has been exposed to violence in the plaintiff's home. As the court likely recalls, after a hearing on the matter, the defendant petition for protection from abuse was denied. Number 9. Finally, the defendant seeks an order of this court requiring the parties to participate in the evaluation of the child for social delays. Such an order is unwarranted for the following reasons. A. The defendant has already exercised her medical decision making authority in her solicitation of several referrals for behavioral testing for the minor child, going as far as to schedule such testing during the custodial time of the father. This matter was the subject of correspondence between counsel of record and the child's guardian ad litem in May of 2025. The father notes that no information regarding the outcome of these appointments were shared with him, despite the court's clear directive that the mother share all medical information related to the child. B. The plaintiff avers that whatever issue the child has previously faced when adjusting to new care settings, as there have been several based upon the defendant's repeated changing of daycares, have improved over time after the child became acquainted with the new location. There is no reason the same would not be true for this transition to starting elementary school. C. As the result of a pending action in Huntsville Municipal Court, the plaintiff is limited in his contact with the defendant except for the limited purposes of effectuating the transfer of the custody of the minor child. The defendant now asks that the plaintiff be required by court order to coordinate and cooperate in further testing and evaluation, which the plaintiff does not consider necessary, and which would run the risk of violating restrictions faced by the plaintiff in connection with the municipal court action. Number 10, the plaintiff has incurred unnecessary legal expenses as a result of the defendant's actions and spurious allegations. Wherefore, the plaintiff moves the court to enter an order denying the defendant's motion and all relief requested therein, or in the alternative, to set a hearing on the same prior to the entry of an order granting any relief to the defendant based on said motion. This party further requests any and all further relief to which, in equity and good conscience, the plaintiff may be entitled under the foregoing circumstances, including but not limited to an award of an attorney's fees associated with the defense of this motion, any and all costs associated with a hearing should one be held, and it is signed, you guys, and his attorneys are listed. So what do you guys think about LeBeric's motion denying everything Destiny said? Let me know down below in the comments. Don't forget to hit that like button, and I'll see you guys in the next one. Bye.